The general rule of law is the person who makes any allegation has to prove his case. So what practically happens in court is the plaintiff, that is the person who has filed the lawsuit, has to prove his case by leading the evidences first. After his side of evidences are complete, the defendant will lead his side of evidences just to counter the evidences of the plaintiff. And if the plaintiff fails to prove his side of case, he will lose the case. This is the rule of the game. But what if I tell you, even if you have filed a case against someone, you do not have to prove your case. You do not have to lead evidences first. You can make your opponent, the defendant, to lead evidences before you. And he has to prove his case. Not you have to prove your case. And if he fails to prove his case, you will automatically win. This is a powerful winning tactic. But this is not commonly used in courts because it requires intelligent craftsmanship of the drafting of the case. So the key concept is burden of proof, that is who is responsible to prove the case. So if you are alleging someone, you have to prove it. But if you are molding the case in such a way that the burden of proof shifts on the other person, the winning probability can significantly increase. For this, we will see a real life court example. But before that, let us understand the relevant provision of law. So there is no explicit provision of law which says what I am saying today. But there is another provision of law which can help us with various other Supreme Court and High Court rulings to make this possible. So the relevant provision of law is Order 18 Rule 1 of the Code of Civil Procedure, which in simple language says that usually the plaintiff has to start with his case. But if the defendant admits the claim of the plaintiff but still argues that the plaintiff should not win the case because of some other additional facts, in such a circumstance, the defendant can start before the plaintiff. Now let us see a court scene with the help of a real life example. For example, there is a 3-story building with multiple rooms on each floor. There is a person who has 2 rooms on the 2nd floor, and that person takes a bank loan by mortgaging those 2 rooms on the 2nd floor. That person has purchased those 2 rooms for rupees 45,000 only. But just after 4 months of those purchase, bank has granted rupees 30 lakhs as loan by such mortgage because of preparation of some false documents that the mortgager is the owner of the whole building. The real fact is he is the owner of the just 2 rooms on the 2nd floor, but the bank has documented that the person is the owner of the whole building. Now what happened? The borrower failed to pay the loan amount. The bank sued the borrower. The court ruled in favor of the bank and allowed the bank to sell off the property and to recover the dues. Now bank want to auction the whole property instead of just 2 rooms. Now you are the owner of one of the rooms on the 1st floor, and bank is going to auction your room also, which was not mortgaged. Therefore, you have filed a suit against the bank. Now let us consider 2 ways of framing the issues in the case. One way is that whether the plaintiff is the lawful owner of the room on the 1st floor or not. This is not the right way of framing the issue, because by this way the burden will on the plaintiff, that is on you. You have to prove whether you are the lawful owner or not, because you can only prove it. So if you are able to prove, then there is no problem. But if you are not able to prove that you are the owner of that property, of the storerooms, then it will be fatal for your case. But if the same thing has been drafted in another sense and the issues have been framed like whether the entire building was mortgaged to the bank or not, or whether the room on the 1st floor was mortgaged to the bank or not. Now, the mortgage papers are with the bank. So the bank is the best person, legal person here to prove this fact. So the burden of proof is on the bank now. That is on the defendant, not on the plaintiff. Because it is the bank and only bank who can prove that whether the entire building was mortgaged or not, whether the room on the 1st floor was mortgaged or not. If the bank is unable to prove that the 1st floor was also mortgaged, in such a circumstance, you no need to have to prove your side of case. The bank will lose and you will win the case. But what practically will happen, even after framing of such issues, the court will ask the plaintiff to present the evidences first because the court is habitual of doing this. However, in exceptional cases, the court can direct the defendant to lead the evidences before the plaintiff if the court finds there are some key issues which necessitate such approach. So when the court will follow this approach, let us understand this with the help of various High Court and Supreme Court rulings. So the first ruling is Odisha High Court ruling of 2018, Shraddha Mani Panda versus Chintamani Panda. In this case, the plaintiff instituted a suit for partition of property. The defendant made a plea that property was renovated by their father, and after his death, the property solely belongs to the defendants. So after this plea, the plaintiff made the application under the relevant law which I have told in this video, that is Order 18 Rule 1, and sought from the court that the defendant should lead the evidences first. Now the trial court accepted that application, admitted that application, and directed the defendant to lead the evidences first. Against this order, the defendant went to Odisha High Court. Odisha High Court confirmed the order of trial court and ruled that the defendant was liable, was duty bound to lead the evidences first before the plaintiff, and after that plaintiff has just to counter the defendant's evidences and no need to prove his side of case. Now in a latest Delhi High Court ruling of 2020, Achala Mohan versus Jayshree Singh, Delhi High Court ruled that if the defendant's argument once proved can entirely resolve the whole case, the court can direct the plaintiff to present his side of evidences before the plaintiff under Order 18 Rule 1 of the Code of Civil Procedure. Now another ruling is of Madhya Pradesh High Court, Radha Traders versus Chakulal. Now in this case, the plaintiff alleges the defendant that he has signed the check. The defendant admits that yes, the defendant has signed the check, but the check was obtained by fraud by the plaintiff. Now this element of fraud is an additional fact which was not alleged by the plaintiff. So the defendant has to prove this fact now by leading the evidences before the plaintiff. And the court held in this case that if the defendant fails to prove the element of fraud, the plaintiff will win automatically without even leading his side of evidences before the defendant. Now in another Odisha High Court ruling, Purushottam versus Chaturbhuj, which is a ruling of 1991. In this case, the plaintiff filed a suit for partition of a property. The defendant said that the property was already partitioned. Now this already partitioned is a new fact, additional fact. So the court held the defendant has to lead the evidences first and plaintiff has just to submit the counter of those evidences. Now let us see finally what Supreme Court says on this point. So I am going to take you on the latest Supreme Court ruling of 2024. Jami Venkat Suryaprabha versus Tarini Prasad Nayak. The court held there is no impediment on the court to call upon any specific person, any specific party to lead his evidences first. It all depends upon the facts of the case and the way the issues have been framed. Very important, I repeat, the way the issues have been framed. When the court finds that the defendant's plea strikes the root cause of the case, there is no bar in asking the defendant to lead his side of evidences before the plaintiff. Therefore, by intelligent drafting of your case, you can mold the facts so that the issues are framed in such a way that the burden shifts from you to the defendant and he has to lead the evidences, he has to prove his case and not you. And once such issues have been framed, you can move an application under Order 18 Rule 1 of the Code of Civil Procedure and use the various rulings which I have used in this video. This will help in significant increasing of the probability of winning of the case. In the end, I would like to ask you, would you like to know more of such tactics and strategies to strengthen your approach in the legal battle? Let me know your answer in the comment box and I shall wait for it. Thank you very much and I wish you all the best.